Hello everyone, welcome back to Criminal Procedure. For this video, we will discuss to you about the principle of double jeopardy. What is double jeopardy? In ordinary sense, jeopardy means the danger of loss, harm, or failure. In law, jeopardy means the danger arising from being on trial for a criminal offense. Double jeopardy as a criminal law concept refers to jeopardy of punishment for the same offense, suggesting that double jeopardy presupposes two separate criminal prosecutions. Basis of double jeopardy. Section 21, Article 3 of the Constitution of the Philippines provides that no person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Elements of double jeopardy. First, there must be a valid indictment, which means that the complaint or information must sufficiently allege the facts required by the rules of court. So, the basic requisites for the sufficiency of a complaint or information must have been complied with. Take note that double jeopardy will not attach if the complaint or information do not constitute an offense. Second, competent court. When you say competent court, it means that the court has the jurisdiction over the criminal case. The requisites for the exercise of jurisdiction must be complied with. One is jurisdiction over the offense charge. Second, jurisdiction over the person of the accused. Third, jurisdiction over the territory. Third, there must be an arraignment because the absence of arraignment results in the nullity of the proceedings before the trial court. Fourth, the accused must have entered a valid plea. So if the accused has entered a conditional plea, then that plea will not be valid. Or if the accused made an improvident plea. Fifth, that the case must have been validly terminated. So let's go back to valid plea. So we said that the plea must not be conditional. So it means that if, for example, the accused enters a conditional plea and the trial court rendered a judgment convicting the accused based on his conditional plea, the Supreme Court held that the plea was not valid because since it was a conditional plea, the trial court should have vacated such a plea and entered the plea of not guilty, which would require a full-blown trial before judgment may be rendered. Or if the plea is an improvident plea, because if the plea is an improvident plea, it is said to be invalid. Fifth, the case or the previous case must have been validly terminated. So when you say a valid termination, it can be done in any of the following ways. Number one is if the accused was either convicted or acquitted in the previous charge, or if the case against him was dismissed or terminated without his express consent. The rule contemplates that the first jeopardy had been validly terminated, and because of such termination, the accused could no longer be exposed to another jeopardy. So let us distinguish between acquittal and dismissal. Under the rules, an acquittal is always based on the merits. That is, the defendant is acquitted because the evidence does not show the defendant's guilt beyond reasonable doubt. But in dismissal, it does not decide the case on the merits or that the defendant is not guilty. Remember dismissals by virtue of filing a motion to quash? So since it is not a decision on the merits, then the prosecution can refile the case because it does not dispose of the merits of the case. Second, in acquittal, the double jeopardy is always available. But in dismissal, either the court is not a court of competent jurisdiction or the offense was not committed within its territorial jurisdiction, or the complaint or information is not valid or sufficient. So these are some of the grounds for the dismissal of the complaint or information. But take note that in order to invoke double jeopardy, the dismissal must be without consent of the accused. So let us have an illustration. Dismissals without express consent. So People versus Espinosa, 409 SCRA 256. Espinosa sought the permission of the court to travel abroad pending the results of the reinvestigation of his cases before the ombudsman. Before granting its permission, the court required him to be conditionally arraigned. While he was abroad, the ombudsman moved to withdraw ex parte the cases. But later, the ombudsman filed a reinstatement of the previously dismissed cases, to which Espinosa objected. The issue here is whether or not the reinstatement of the cases will violate the right of the accused against double jeopardy. So the Supreme Court held in this case that upon examination of the records of the case, it was found that there was no conditional plea. The fact that it was designated as such by the judge does not make it a conditional plea absent any showing that the accused clearly and unequivocally waived his right to invoke double jeopardy. Now let us examine another case. This case of Braza versus Sandigan Bayan. Braza was charged with Section 3G of RA 3019. He was arraigned as a precondition to his authorization to travel abroad. Said condition included a waiver of the right to invoke double jeopardy if the information would be amended. Later, the charge was modified from Section 3G to Section 3E of the same law. Braza moved to quash the second information on the ground of double jeopardy. So the issue here is whether or not there is double jeopardy. The Supreme Court had a different ruling here. As stated in the facts, Braza waived his right to invoke double jeopardy when he entered his conditional plea. It was found by the Supreme Court that Braza clearly and unequivocally waived such right, and therefore he was stopped from questioning the second information on the ground of double jeopardy. The difference between the cases of Espinosa and Braza is that in the former, the plea was found to be unconditional and there was no waiver of the right to invoke double jeopardy. While in the latter, the plea was conditional upon the accused's waiver of his right to invoke double jeopardy. Dismissals equivalent to acquittal. As a general rule, we said that to invoke double jeopardy, the dismissal must be without the express consent of the accused. But there are exceptions to the rule when the accused consented to the dismissal of the case, but still he can invoke double jeopardy. And what are the exceptions? Number one is if the case was dismissed due to demurrer to evidence. Because if you can remember, demurrer to evidence is filed by the accused. So if the case will be dismissed based on demurrer to evidence or based on the insufficiency of the evidence of the prosecution, then such dismissal will be considered an acquittal, and therefore any refiling of the same case will constitute a violation of the principle of double jeopardy. Second one is if the case was dismissed on the ground of violation of the right of the accused to speedy trial. So we said in our previous class that if this is the ground for the dismissal of the complaint or information, although the dismissal is with the consent of the accused, the dismissal is said to be an acquittal, and therefore the accused can invoke double jeopardy in case the prosecution will refile the case. Third, discharge as a state witness. The discharge of an accused to be a state witness shall amount to an acquittal and shall be a bar to a future prosecution for the same offense, unless the accused fails or refuses to testify against his co-accused in accordance with his sworn statement constituting the basis for his charge or his discharge. Effect of double jeopardy. In criminal cases, double jeopardy bars another prosecution for the offense charge or for any attempt to commit the same or frustration thereof, or for any offense necessarily includes or is necessarily included in the offense charge in the former complaint or information. Finality of acquittal doctrine. The accused is entitled to repose as a direct consequence of the finality of his acquittal, and this doctrine has several purposes to it. Number one is that it prevents the state from using its criminal processes as an instrument of harassment to wear out the accused by a multitude of cases with accumulated trials. Second, it serves to preclude the state following an acquittal from successively retrying the accused in the hope of securing a conviction. And lastly, it prevents the state following a conviction from retrying the accused again in the hope of securing a greater penalty. Double jeopardy does not apply despite a prior conviction. So general rule is a conviction for the offense charge bars prosecution for the same offense. Exceptions to the rule are the following. So this means that if the following instances are present, then the accused can still be prosecuted for the same offense. But first, let us go to the meaning of the same offense. Ano pala ang ibig sabihin ng same offense? It means for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charge. The court clearly emphasized that the same criminal act may give rise to two or more separate and distinct offenses. No double jeopardy attaches as long as there is a variance between the elements of the two offenses charged. There is simply no double jeopardy when the subsequent information charges another and different offense, although arising from the same act or set of facts. So let us have an example of identical acts but constitute different offenses. Number one is theft of electricity under the revised penal code versus violation of PD 401 as amended. So, the Supreme Court held in the case of Diaz versus Davao Light and Power Company Incorporated, 520 SCRA 481, 510 to 512, that what generally makes the former a felony is criminal intent or negligence. So this refers to the theft of electricity under the revised penal code. And what makes the latter a crime is the special law enacting it. In addition, the elements of the two offenses are different from one another. In theft, the elements are intent to gain, unlawful taking of personal property belonging to another, and the absence of violence or intimidation against persons or force upon things. On the other hand, the crime of violation of PD 401 as amended by BP 876 is mala prohibita. The criminal act is not inherently immoral, but becomes punishable only because the law says it is forbidden. Okay, so even if these are identical offenses, but since they have different elements, so they are not considered as same offense in order to invoke double jeopardy. So if the accused was charged with theft of electricity and violation of PD 401 at the same time, he cannot invoke double jeopardy because in order to invoke double jeopardy, it must refer to the same offense, which means that the two offenses must have the same elements. Another example is illegal recruitment versus estafa. So here, these two crimes or offenses have different elements, and therefore, the accused cannot invoke double jeopardy if he is being tried with these two offenses at the same time. Same is true with violation of BP 22 versus estafa. Kasi nga, di ba, in BP 22, it is a special law. It is a malum prohibitum, while estafa is provided for under the revised penal code, which requires criminal intent. Same is true with direct bribery versus violation of Section 3B of Republic Act 3019. So again, the conviction for the same offense charge bars prosecution for the same offense. Okay, so if you are convicted before of an offense and there is another offense that has being that is being filed against you arising from the same act and same yung offense na final, so that will bar that will not be allowed no under the principle of double jeopardy because that constitutes same offense. But there are acts or omissions which are identical in nature but identical acts but are considered as different offenses under the law, and therefore even if they arise from the same act or omission, double jeopardy cannot be invoked. So we said earlier that the general rule is it must be for the same offense. And we defined the phrase same offense as an attempt to commit or a frustrated stage thereof, or any offense which necessarily includes or is necessarily included in the offense charge in the former complaint or information. Example of that, if you are already convicted with frustrated homicide, so hindi ka na pwede i-convict with attempted homicide or consummated homicide. Kasi ang sabi dito, you cannot be prosecuted with an offense which is an attempt to commit it or a frustrated stage thereof, or any offense which necessarily includes or is necessarily included in the offense charge in the former complaint or information. Example is murder and homicide. For as long as they arise from same unlawful act or omission. But that is only a general rule because we have exceptions to the rule. The exceptions to the rule are the following. Number one is if the graver offense was developed due to supervening facts arising from the act or omission constituting the former charge. So the example of this is when the offense was committed, the act merely resulted to a serious physical injury. You know, when the physical injury is serious, it requires hospitalization. What if, for example, while the victim was hospitalized, he died? Meaning to say the death supervened only after the commission of the offense. So if this is the case, a new information may be validly filed charging a graver offense without violating the principle of double jeopardy. Double jeopardy does not exist because one cannot be in jeopardy for an offense which did not as yet exist at the time of the filing of the first information. Second exception is the facts constituting the graver charge became known or were discovered only after a plea was entered. Example is the accused was charged with reckless imprudence resulting to homicide for hitting a pedestrian. After the accused entered his plea, it was discovered later in the investigation that the accused had an ill motive against the victim, that the accident was intentional. So the prosecution may file a new information or may amend the first information on the ground of newly discovered evidence. So take note here that the fact uh, is existing at the time of the commission of the offense, but it was only discovered later after the accused had entered his plea. But in the first instance, the fact or the supervening fact exists only after the commission of the offense. So take note of the difference between the two. The third one is that the plea of guilty to a lesser offense. So here, if the accused will plead guilty to a lesser offense, then that is an exception to the rule that he cannot be convicted or prosecuted for the same offense because alam naman natin na in plea bargaining, merong consent yan ng accused and therefore, he cannot invoke double jeopardy. If you can still remember in plea bargaining, di ba, the accused had already entered his plea on the original charge and then if he pleads guilty to a lesser offense, then his prior plea will be vacated and a new plea will be entered on the lesser offense. So, even if nagkaroon na siya ng previous plea sa original charge, tapos ngayon, nag-plea na naman siya for the lesser offense, it will not constitute double jeopardy. Kasi in the first place, may consent yan ng accused, may consent yan ng prosecution at saka ng offended party. So, effect of double jeopardy in civil cases. The acquittal of the accused does not affect the right of the offended party to appeal the civil aspect of the case. So, the offended party or the accused may appeal the civil aspect of a judgment. So it has been said that while a judgment of acquittal cannot be appealed by the prosecution, so di ba bawal na mag-appeal si prosecutor sa judgment of conviction. Otherwise, it will constitute double jeopardy. But either the offended party or the accused may appeal the civil aspect of the judgment despite the acquittal of the accused. The reason here is that because the concept of double jeopardy has reference only to criminal cases and it has no effect on the civil liability of the accused. The Supreme Court said that ang paggamit daw ng word na punishment, offense, conviction, and acquittal in the Constitution and the employment of the words convicted, acquitted, information, prosecution, and attempt to commit or frustration thereof leave no doubt as to the concept's non-application to a civil case. And also, remember yung principle natin na the extinction of the criminal liability will not necessarily give rise to the extinction of the civil liability. And also, under Section 4 of Rule 111, if the accused dies before his arraignment, while the criminal case shall be dismissed because of its extinction, such dismissal is without prejudice and shall not be a bar to any civil action which the offended party may file against the estate of the deceased. So the estate therefore cannot invoke double jeopardy. Similarly, under the same provision, even if the civil liability arising from the delict or criminal act is extinguished when the accused dies after arraignment and during the pendency of the criminal action, the independent civil action arising from other sources of obligation may be continued against the estate of the deceased. What about in quasi-offenses? So the doctrine that you should remember here is that reckless imprudence under Article 365 is a quasi-offense by itself and not merely a means to commit other crimes. Hence, conviction or acquittal of such quasi-offense bars subsequent prosecution for the same quasi-offense, regardless of its various resulting act. For example, the accused was charged with two informations. One is reckless imprudence resulting to damage to property, and the other is reckless imprudence resulting to serious physical injuries. Both crimes arose from the same act or omission. The accused pleaded guilty to the first information. Therefore, he can no longer be tried for the second information because it arose from the same act or omission. So, hindi pwedeng sa isang act, dalawang reckless imprudence. So dapat yung prosecutor, ang final niya na case is isang reckless imprudence, tapos i-complex niya na lang yung mga resulting crimes like resulting to damage to property and serious physical injury. So hindi pwedeng ipaghiwalay niya for hindi siya nagadepende sa resulting crime. Because reckless imprudence by itself is a single quasi-offense. So hindi siya pwedeng i-divide, no? For as many resulting acts as there is, no? So let's talk about provisional dismissal. Under Section 8 of Rule 117, a case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. Actually, the rules did not specify on what ground a criminal case may be provisionally dismissed. What is important here is that the provisional dismissal must be with the express consent of the accused, and second, with notice to the offended party. If any of the requirements will not be complied with, then the provisional dismissal will not, or the accused can invoke double jeopardy, no, kapag walang consent niya, walang express consent. So, but this provisional dismissal, hindi ito forever because the dismissal will become permanent when if the offense has a penalty of not more than 6 years, or we say 6 years and below, then it will become permanent after 1 year from the issuance of the order of dismissal without it being revived by the prosecution. And second, if the offense has a penalty of more than 6 years, then it will become permanent, or dismissal will become permanent after 2 years from the issuance of the order of dismissal without the prosecution reviving the case. And also here, take note of Section 10 of Administrative Matter 12-11-2 of the Supreme Court, which provides for instances or grounds, no, for provisional dismissals. No, pwede yung court yung mag-dismiss ng case provisionally. Number one is if there is an absence of an essential witness because his whereabouts is unknown or cannot be determined. So hindi alam ng prosecution kung nasaan na si essential witness. The second one is if there is an absence of an essential witness. Although, and his presence cannot be obtained by due diligence, although his whereabouts are unknown. So here, the court shall provisionally dismiss the action with the express consent of the detained accused, provided the hearing in the case has been previously twice postponed due to the non-appearance of the essential witness, and both the witness and the offended party, if there are two different persons, have been given notice of the setting of the case for third hearing, which notice contains a warning that the case would be dismissed if the essential witness continues to be absent, and there is proof of service of the pertinent notices of hearings or subpoenas upon the essential witness and the offended party at their last known postal or email addresses or mobile phone numbers. So for the above purpose, the public or private prosecutor shall first present during the trial the essential witness or witnesses to the case before anyone else. An essential witness is one whose testimony dwells on the presence of some or all of the elements of the crime and whose testimony is indispensable to the conviction of the accused. So, let us distinguish between withdrawal of information and motion to dismiss. A motion filed by a prosecutor to withdraw an information differs from a motion to dismiss. While both put an end to an action filed in court, their legal effect varies. The order granting the withdrawal of the information attains finality after 15 days from receipt thereof, without prejudice to the refiling of the information upon reinvestigation. On the other hand, the order granting a motion to dismiss becomes final 15 days after the receipt thereof, with prejudice to the refiling of the same case once such order achieves finality. A motion to dismiss when filed thus puts into place the time bar rule on provisional dismissal. So, yan yung difference between withdrawal of information and a motion to dismiss. Kasi sa motion to dismiss, mag-a-apply yung time bar rule, itong 1 year and 2 years as the case may be. But in withdrawal of information, hindi siya time barred. And therefore, it does not fall within the ambit of Section 8, Rule 117 of the Revised Rules of Criminal Procedure. So if the case is withdrawn, so hindi mag-a-apply yung 1 year and 2 year period. So hindi siya magiging permanently dismissed kasi hindi applicable sa kanya yung time bar rule. But with respect to motion to dismiss filed by the prosecutor with the consent of the accused, so subject siya sa time bar rule. And take note that these grounds under Section 10 of Administrative Matter 12-11-2 require dito yung consent ni accused. Kailangan may express consent ni accused. So kahit na there is a ground, like wala yung essential witness, kapag hindi nag-secure si court or si prosecutor ng consent, express consent ni accused, then hindi magiging provisional yung dismissal. It will be considered as an acquittal and therefore the accused can invoke double jeopardy. So that ends my discussion for double jeopardy. So see you next video.